my motions because I've got to stay within a certain space, although I can move around. Last I saw this even in virtual space. This is truly a law course because even in virtual space, nobody's sitting in the front row, which is endlessly amusing to me. All right, so today we are near the end. The third and final class of the controlling meme. So we've gone from creating to connecting to controlling. And this is essentially, this meme is about can you put the genie back in the bottle? What measures and countermeasures are possible? And where does the law intervene? Does it intervene too much? Does it intervene not enough? First step was talking about copyright and originality. Second step under controlling was misogyny and violence and Gamergate. And today we're talking about privacy and surveillance. I should mention that when we rebooted the course into its kind of current 2.0 version, there wasn't a whole lot that seemed obviously part of video game law in terms of privacy. I mean, there were some issues. Mostly there were concerns. And very rapidly it turned into my thickest file and even thicker than the violence and sexism file. We heard earlier at the beginning of the semester sort of advice to you that if anybody seriously wants to become part of the industry as a lawyer, privacy is where there seems to be no end of issues. Having said that, I will give you one caveat. There are no easy answers, which is why there's no end of issues here. So this is not one where I can even pretend to wrap it up in a neat theoretical bow. This is really a class of questions more than anything. Mentioned already that we've got a divided class. We'll see how that goes. The video of what the students on the Rift see will also be posted on the website, so you'll be able to spend a few minutes with that. Term papers, we're getting really, really close. Almost everyone has contacted me. If anyone hasn't, please do. All of the coordinates are on the syllabus on the course website. Want to point out one thing. When Jennifer Kelly was here 2 weeks ago, she alluded to a lawsuit that she was filing, if anyone recalls. This is the lawsuit. It's against a Vancouver company called Hothead Games. Jennifer is acting for Glue Mobile, who does Deer Hunter, and the lawsuit against Hothead is about a game called Kill Shot. It's interesting to go through the pleadings. There are a number of stories that you'll find on the web, and apparently even mistakes in Deer Hunter were replicated in Kill Shot. On the other hand, in Kill Shot you have a situation where the skin of the game seems quite different. So you'll see different perspectives. And for those of you writing papers on originality, certainly this is the cutting edge lawsuit. And I don't know how much more we'll hear by the end of this course, but certainly we'll hear a lot more about this in 2015. So privacy is a tough one. We are really, when we're dealing with video games, because we come from originally from sort of a single-player hard disk modality for so many years, privacy was never a huge concern, and at least in terms of gameplay. But in recent years, it's become a very obvious concern, and we'll talk quite a bit about how and what's caused that. But I'll just point out that we've got a Connect 2.0 for the sake of the Oculus that's right in front of me, and we have a bunch of people in another room watching me. Now, that's all by consent, but it gives you a sense of the power of the technology and what happens if, in theory, it's not by consent. This is not a difficult setup, as you can see. So the threshold question that seems to come up with university students is, do we care? Do you care about your privacy? There are, and there have been in previous iterations of this class, any number of people who would put up their hand and say, well, no, I don't care. For one of two reasons. Either I'm getting what I want, and it's a trade-off, and I'm a realist, so that's okay. And then there's, I'd say, a smaller minority who go to, well, I've got nothing to hide, so what does it matter? I'm just curious, in this room, how many people would say that privacy is important to them in playing games? Let's put it in a games context. Okay. Let's see where you go. So let's, just to iterate back to the connecting part of the course where we started laying the seeds for consumer protection and where it's going, the Kim Kardashian game. Remember, we talked about this article, and the question was whether it was too easy to confuse what a player might think is a fake Twitter account in-game with the real Twitter account that the game triggers you going out on. And it's this sort of thing that when you look at privacy in games, think about it in these terms. Think about people seeing what you're doing, even if you don't necessarily want them to. Not that I would ever suggest that playing the Kim Kardashian game is an embarrassment to anyone. Far be it for me to say anything like that. Obviously, it's big data that's getting us there, but it's also bad judgment. Now, this is outside of games, but you might remember Facebook's experiment, sort of A/B experiment, where they showed different people different data to see what the scientific results would be in terms of reactions. And actually, it was published in a journal, and nobody seemed, the most troubling thing of the whole exercise was that nobody seemed to catch it as being a problem until the public caught it as a problem and started wondering, hey, that's Are you doing this to me? And then the additional complication that we've always touched on. What about the kids? So as soon as you start implicating kids and privacy, you basically scaffold it to the next level. And you start bringing in, or regulators bring themselves in. I would argue rightly. Others might argue not. Let the magic circle, let the free market, whatever you want to say it is, apply. Or, I guess the other free market approach is let the lawsuits prevail. Now, the regulatory approach is worldwide, and we will have Jaz Purewal in the second half of our class today coming to us from London, England, and he's going to talk about a series of international law issues relating to video gaming. More international, and finally, you've heard this before, what happens when the Oculus is actually got sensors and is measuring your brain and potentially, with your consent, affecting your brain in one way or another to give you a better experience. What happens then? What happens if that gets hacked, et cetera, et cetera? So the issue of privacy, I guess this is the real take-home value. The issue of privacy and the issue of surveillance are essentially the same issue. They are flip sides of the same coin. And in previous years, in a pre-Snowden world, I tended to explain them as two separate things. And I would say this is the first year where I say they're actually one thing that you look at through two different lenses. They've merged. And just so you know what we're looking at is this is a diagram of the GPS satellites around the world and where they are in geostationary orbit. The real point being the satellites aren't actually moving, but the Earth is, as I understand it. But it's a much more interesting graphic. There are lawsuits to figure out the extent of surveillance. But again, surveillance is no longer a standalone word. And in a video game context, it's useful just to briefly go through a small timeline, because all this happens very, very quickly, of the merger of privacy and surveillance. So not that long ago, a little over a year ago, this is a really interesting piece, and not the first one, but it's an interesting piece that points out that video games are part of what makes us comfortable with surveillance. Because in the context of games and multiplayer games, we in effect surveil each other. And I'll show you a little bit more about the dynamic of that. But then we got here. And this was one of the Snowden revelations. And there's some very, very funny pieces online, which you can look for yourself. But the NSA was actually in World of Warcraft. On a covert mission. I don't know what to call it. And the more cynical, there's at least one cynical strain of critics who said that basically a bunch of people in the NSA wanted to play games, and this was a good excuse to do it because, as far as anyone knows, there hasn't been any documented success that came out of that covert online mission. And it does appear like there was a fair bit of resources. Now, all of this becomes very murky, but it's endlessly amusing on one level. On a more serious level, here you go. Privacy, surveillance, one thing, not two different things. And this is an interesting piece because it's an academic piece that, if you're doing a paper in this area, you want to look at it in a fairly methodical way. Just explains how the structure of games accommodates the structure of surveillance and the incursions on privacy. Taking it to a really base level, and this really comes from the paper, just reminders of the in-game artifacts that facilitate breach of privacy / surveillance. We've been watching each other for ages, right? Scoreboards, achievements. You get a fairly good sense of how much time somebody spends on a game, how good they are at it. Multiplayer itself. Now, I've never played a game, I've never spent enough time in a game other than Grand Prix Legends to really know how other multiplayer players think and operate, and in order to make a judgment on them. I certainly, during the time I was spending much too much time with Grand Prix Legends, I certainly had a pretty good idea of certain other racers and how they drove and which ones I would want to drive with on city streets and which ones I wouldn't. But because of the nature of the game, it was a fairly limited experience. Although, I had a fair bit of data because there was also voice at various times. So you get a pretty good idea of a person if you're just lurking within a game context. Now, of course, we've got spectator mode. So you don't even have to play the game to watch people in the game. So if you are the NSA and you want to be snooping, the full modality is right there for you to do it. We have Connect, which gives you all sorts of information, and will give you my facial expressions, et cetera, if the software is there to translate it. And then we have something really interesting for those of you who have a PlayStation 4. There's actually a share button on the controller. It's up here. And it really allows you to send all sorts of things out on the net, whether you're streaming or otherwise. So, and that sort of mode and modes are simply going to grow over time. And anybody here have a PlayStation 4? Okay. Anybody go and check out sort of the live videos that are streaming from various people's homes at various times? Yeah, it can be really, really odd. But you also get a real sense of who you're dealing with and where you are and whether you're in a dorm room or not. And if you cross-reference that to other information that's online, you could probably get a fair bit of information. So So we've set the stage. What do we need to look at and think about from a legal perspective? Let's start small and local. So what does the Privacy Act say in British Columbia? It essentially creates a relationship between what a person's reasonable expectation of privacy is and the privacy, the level of privacy that should be accorded to. It's a very nice test. I'm entitled to the level of privacy that I expect. In very simple form. What do you do with that test in an online setting? What does it mean? Just because you go online, does that mean you expect all your information to be available? How do you apply that test? When you play a game, what does it mean? And and how much choice do you have? Who gives you the choice of how much information is to be shared? And is it really your choice? And you guys know the answer to this question. The answer is, at least in the game context, and probably in most online contexts, it's set by the end user license agreement and the terms of service. So, paper idea, paper point, how do you reconcile traditional notions of privacy that certainly make sense and have made sense with the digital world, with the online world, and with the in-game world? And I'd say those are three different levels. Then there's the collision of rights problem. And that is, what do you do with privacy versus free expression? What happens when those two rights collide? And we don't have a great case in Canada in terms of the online world or the video game world, for sure. But we have a Supreme Court of Canada decision, so that's better than eating crackers, from 2013. But it has to do with old technology, videotaping by a union of those crossing the picket lines. Now, here's the difficult part. They suggested they might post those videos online, and they never did. And the Supreme Court said the union had the right to take those videos and have those videos and use those videos for their purposes. They didn't have to decide whether it would be okay to post them online or not. And in this limited way, free expression, the union's right to free expression, trump the privacy rights of those who cross the picket line. It's hard to take too much from this case and apply it to our world, but it's there, and if you're writing a paper, you need to know about it. So Section 2B1, but we have all of the balancing language that you come to expect and have come to expect in from your constitutional law course in this realm, and you essentially, if you're writing a paper in this area or thinking about this area, would have to write your own Supreme Court of Canada decision to see what you're going to do about the Section 2B Section 1 balancing act in light of privacy. So conclusions on this are very tentative. And the first one is that privacy is not an absolute. I think we know that. But it's become a highly malleable concept in the digital world. And we really have not figured out how to put Humpty Dumpty back together again. And that's why the advice in the first or second class was, if you're going to go into any area, go into privacy. Because it's going to be a dialectic for the law and within the law for quite some time. All of this becomes very complex in a commercial environment, which video gaming largely is, because freedom of expression is being invoked by the developers and by the distributors. The one concept that we can hang on to as being useful is the notion of express consent. However, what does express consent mean in the context of end-user license agreements and terms of service, where express consent is being given knowingly or not? So, what can we reconcile here? What are possible ways forward? And this is even more tentative than the previous conclusions, but just to give you some things to think about, as opposed to answers. But if you, we may, or you may find, I have far greater hope for you finding it in your time than old guys like me finding it in the near term. So what's reconcilable? Moral rights. Moral rights is an interesting piece. It's an intellectual property piece, but, and we've talked about it previously at some length in the course, but remember, it has to do with the concept of integrity and integrity of your work. So maybe if you can transpose that onto integrity of your information and your right to control whether you're associated with your information or not, it may be a useful concept, because you can almost map moral rights onto privacy and get something useful and interesting, because the core concepts make sense. And that takes you to the right to be forgotten, which is being implemented in Europe. There's various levels of criticism of it. It's very hard to implement. I'm going to be talking to a colleague who wants to write a paper on the right to be forgotten and how to think about it in journalistic and legal terms this afternoon. So it's a bedeviled concept. I'll point out that it's not inconsistent with moral rights, and that neither of these concepts do badly if you put them against a kind of post-structuralist interpretation, because, as has been discussed at length, at probably too much length for your liking, it's about the gamer, it's about the individual, it's about the rights of the people who not only participate, but actually create the game. Pour the wine into the bottles. And so in that context, thinking of privacy and thinking of the freedom from surveillance. Certainly surveillance you don't know about, which is the definition of surveillance, in my view, makes some sense. And there's one other concept I think may be useful here. And it's an old concept, freedom of thought. This is the current iteration of J.B. Bury's book, which is a very old book called Freedom of Thought, A History. I've chosen the far more dystopian cover that I found online. And I'll point out that it's available as a free ebook. So if you're interested in this area, it's easy to get. And freedom of thought has generally been about freedom of religion. And it's sort of halfway between freedom of religion and freedom of expression. And Bury occupies well that middle territory. Please do read the book, because these aren't the only two important passages if you're interested in this area. But sort of given you a very, very short form of what's the question and what's the answer here. So the question, the problem that Bury wrestles with is that governments have a tendency to argue that it's their responsibility to prohibit the circulation of pernicious opinions. And as you will read, that kind of knows potentially no boundaries. And Bury's answer as to why freedom of thought is important is that after looking at things for 165 pages, if the history of civilization has any lessons to teach us, it is this: there is one supreme condition of mental and moral progress, perfect liberty of thought and discussion. It's my suggestion that freedom of thought is potentially going to be an extremely important concept in a world of surveillance, in a world where privacy is the issue, in a world where people through big data can reach all sorts of conclusions about you and potentially manipulate you. Why? Because expression is aligned with, if you're expressing yourself, and this is kind of the classical argument that you would find in a digital commercial concept. Well, you're choosing to go on Facebook. This is stuff you're putting out there. Don't tell us, the government or anyone else, that we don't have the right to look at what you're doing. You're doing it. Where freedom of thought is interesting is that it goes right to the kernel of what's truly private. And if freedom of thought really operates, then without expression, nobody should have a right to know anything about you. And yet they do. So how does that get reconciled? So I have a suggestion that freedom of thought be used, be resuscitated as a legal tool in looking at these issues and pushing through them. Also, freedom of thought gives us another, I think, reinforcement of the post-structuralist argument, and that is that the freedom of your thought and the freedom of my thought are not going to be the same. Our thoughts are not going to be the same. How we define the freedom is not going to be the same. We're all different. We're all users of the concept by being human. Just some stuff on the right to be forgotten. I will make one comment on Article 16. And you guys will do much better than me if you're looking at this in terms of a paper. It is really, really hard to find the actual locus of the right to be forgotten. The document is painfully obtuse. I'm sorry if I'm insulting the drafters of it. And sort of how you get there is really difficult from a legal structuralist perspective. As law students or as lawyers reading through, it's not like, oh, there's a right to be forgotten. It's not nearly that simple. It will cause you some pain if you're writing in this area. The case, however, that created so much kerfuffle is interesting. It's an individual who wanted the removal of web links to an article in a Spanish newspaper about an auction for his foreclosed home, and he had subsequently paid off his debt. And therefore, when you looked, if you Googled this individual, the first thing that came up was this implication that he had not paid off his debt when in fact he had. And so ultimately the European Court of Justice said he had a right to be forgotten. How far does that go is the question in a Canadian context. It's awesome paper. Would the right to be forgotten survive Section 1? So when you look at the Oakes test, when you look at our balancing act, what would we do? And that's a complete unknown. I mean, this is, now, if you're going to turn it into a paper, you have to bring it back in some way to a video game context, but that's not really hard to do. And in my case, do I really want my times from Grand Prix Legends at Monza, in 2001 to ever be seen online? Which is clearly defamatory of my abilities. In any event, sorry, couldn't resist. So I'm working backwards here, but just to give you a little bit more detail on what this looks like. So then we have the moral rights piece. And this is from the Copyright Act. Just a reminder, the right to the integrity of the work. And we're reasonable in the circumstances, which people almost always forget to read, to be associated or not associated with the work. Not clear what reasonable in the circumstances mean. There's kind of one other concept. It's hard to know what to do with this one, but it's a very important one. And that is, let us not forget that law itself can be reduced to code. And we could actually build the rules into the software. So we could build the rules of privacy and surveillance much more so than we have. right into the devices, right into the programs we use. Should we, shouldn't we? Ultimately, I bring us back to McLuhan because he, in a small way, gives us the answer to our confusion without taking away our confusion. This is a tautology. Games are models of a culture, and our culture is confused about privacy and what it means in a digital age. So our games reflect that confusion right now. Our digital world reflects that confusion right now, because our culture is confused. So right now it's a bit of a vicious circle. How do we break it? What does privacy mean in games? And again, here's where that's as close, we've gone as close to finding answers as we're going to. Now I'm just going to remind you of some concepts. Games have always wrestled with the question of identity. Video games had avatars right from the beginning. I mean, it's incredibly fitting that I'm appearing as an avatar to another classroom in this law school right now. VC is a game technology right from the beginning. And we've always had confusion about what that means. And I'm not going to give you the post-structural answer, but because we've already explored that. But the question of what is the avatar, what does the avatar mean, what does it mean in terms of the magic circle and law are questions we've explored. Another issue. Video games have had community for a very, very long time. In your mind, does having community mean you don't want privacy? And to go to the traditional notion of what privacy means, what does a reasonable expectation of privacy mean in the context of an online community? Do you have no expectation of privacy when you join a community? Or do you have some? I do. I have some. I think there are rules of the road. But that's the core tension. And when you play a game, if you join, if we're friends, I get to know what games you're playing and when in a PS4 and a Xbox One context, if we're friends online. Now, I've consented to that. You've consented to that. There are not nearly enough sliders to control. I don't know how many people I want to know exactly what I'm doing and when. I'll simply point out that my son, who plays a lot of video games, has never chosen to be my friend in a video game context. And why? Because he knows that I would say, well, what's happening with your homework? Don't you have an exam next week? So these are real issues. The key difference, I talk about privacy and surveillance is the same. The one obvious difference is that privacy is, at least in theory, I should have put in theory, a negotiation through your end user license agreement. There's no negotiation in surveillance because you don't know about it. The two are often confused. And you've seen this layers of control slide. I just want to give you a sense of how pervasive. I've just tried to identify where privacy and surveillance issues show up. And I may have missed some of these, but sort of fully half of the layers of legal control directly implicate privacy and surveillance. And the problem is growing. We've talked about telepathic games and how serious that can be. And I'm not sure I showed you this before, but I alluded to it. So I wanted to find the actual article. This is from MIT News from over a year ago. Neuroscientists plant false memories in the brain. So this is how far it can go. I'm not going to go through this because we don't have time, but this is just a map for when you're a creator or a gamer, what happens, what are the layers of information that you're providing. And the two moving forward questions, what happens to the magic circle? And I was somewhat comforted by the show of hands earlier. Is this even an issue to the digital generation? It seems to be. There's a Pew study, a mini Pew study that came out just today, so it'll be in News of the Week, that tends to show, yes, people are concerned about privacy. And there was some thought previously that really it wasn't that big a deal. I'm just here tracking through on a surveillance side so that you can see some of the law with respect to search warrants. And I just want to spend a little time on this slide. And this is, and I'm not picking on Sony, just an example of their privacy policy from 2011. And this is the actual wording. Where and to the extent required by the applicable laws, you hereby expressly consent to your personal information being shared with or otherwise transferred by Sony Online Entertainment to third parties. It's really, the lawyer on this did a fabulous job for Sony, not for you. Sorry for the small type. I really do want to send you to this article. Evgeny Morozov, who is rather controversial on many things and who I don't necessarily agree with on many things, wrote a wonderful piece on privacy, saying essentially the law is only of limited help. This is a political issue, and it needs to be solved politically. And we must learn how to sabotage the system. We must learn to not self-track. And we need digital services that come through and protect our privacy as a competitive advantage to them. And we're starting to see Facebook and Google take some steps in this direction. Is this reconcilable? I've already suggested that moral rights might help us reconcile it, and that freedom of thought may be another mode of reconciliation. What's at stake? This is a sleeper. And it's very little talked about, and it really goes directly to Bury and freedom of thought. And you have to kind of look deeply at yourself. If you don't have privacy, if you feel you might be surveilled, how much does that chill your expression? That's where the core to the answer is going to lie. I don't think there's any doubt that it chills expression. How much, how, what are the modalities, what will make you feel less chilled, how do we legalize that? Just lots of material here, lots of articles. If you're doing a paper on privacy, a bunch of very good academic links, various papers, which you could go through at your length, at your leisure, not at your length. I do want to point out that there is some really good current work, like this semester current work, being done on privacy legal theories, because the issue is really joined now. So I've given you a series of links here, Privacy in Public by Joel Reidenberg. This one I love. James Whitman of Yale, The Two Western Cultures of Privacy, Dignity versus Liberty. And what it points out in short form is that we are not at Edom between Europe and North America on the purpose of privacy. And that's one of the obstacles in dealing with concepts of privacy and surveillance legally, because we don't see the core purpose the same way, and that in Europe, European norms are founded in dignity and personal honor. So think of the Spanish case. I actually paid my debt. That's about personal dignity, about personal honor. And the North American concept is liberty, is freedom. I should be free to say, think, and do whatever I want. It's not about my honor. It's about my rights. And until that gets bridged or gets better understood, you kind of have a bifurcated world on privacy surveillance issues. And even in this area, there's Paul Ohm's piece on sensitive information. And I already did Reidenberg. So we've come to the end. Sorry, had to do that. We're going to take a break and switch over. I hope that the Oculus experience was a good one and an interesting one. I look forward to hearing about it. And we are now going to get Jazz Purawal from London on the line, as it were. So take a 2-minute break.